Well, this is the 16th of November, 2009, and there's something more I wanted to say about juries before I move on to some other subject. Recently, in the province of Ontario, it became known that the Attorney General has for some time, or his representatives, that is, been cooperating with the police in receiving information prior to trials from the police database, be it of criminal convictions or of more casual and less serious interactions with the police by people who were in what's known as the jury panel, or that are going to be selected for jury duty. This process enabled the Crown to pre-select the jurors and get their preemptory challenges or their stand-asides, which they would have an unlimited number of, the process whereby they're not actually challenging, they're standing aside for a later consideration. This process gave the Crown a tremendous advantage. What I'm trying to get at here is that the state has always tried to meddle with the jury process in recent times to give the state an advantage. And this is something that's gone on for decades, if not maybe even centuries. The influence that the state or the government or the Crown has on the selection of the jury process undermines the very nature of the jury process, which should be finding impartial individuals who are not committed either to the Crown, the state, or to the government, or to the individual accused. It therefore becomes very important that we preserve the essence of the jury system and remind the jury that theirs is the most important decision of the entire criminal justice process, and indeed the civil process, because there are civil juries as well, for motor vehicle accidents, among other things. But the jury must be made aware that they have the power to find guilt or innocence, liability or no liability. They have the power to make that decision. Yes, it has to be based upon the law, but the essential question is, how does the law apply to the facts, and what was the state of mind of an individual accused at the time when the offense was committed? And they should be given the widest possible latitude to determine that on the basis of common sense and their own inherent judgment about the nature of human beings, because after all, they are the reasonable man and woman. And another aspect of this question, the jury power and the jury verdict, is essentially that they should have the right to determine whether the law can be morally applied, whether the law as written can attack a culpable mind, or does it attack an innocent mind. And if it attacks an innocent mind, then they should not allow a conviction upon it, because it is the guilty mind that they have to decide upon. And if they cannot find one, even though the law might be broken, why should they not be allowed to acquit? And in addition to that, there should be more jury trials for a wide variety of subjects, including what is in the public interest in the prosecution of criminal charges against police. There should be a civil jury process, much like the jury process in the United States, the grand jury process, to determine if charges should be laid against police officers. They should be ordinary citizens. They should not be police investigating police, and then Crown prosecutors exercising discretion to say, well, we don't think that a conviction could be obtained. How do they know? Unless they can read the mind of ordinary people, they're no more entitled to do that than any other citizen. And there should be jury trials, for instance, in matters involved with the Law Society or any administrative tribunal. These administrative tribunals should not have the power that they do to decide guilt or innocence in professional conduct. And in other areas of public life where the public interest is involved, there should always be a jury determination possible at the option of the accused. That's a simple principle that we should work towards, so that the special interest groups and the little cliques that run the professional societies should not be able to exercise their political sway to the prejudice of the public interest. The jury is the best repository of the public interest.